know that it's not about the family. And it's not about socialism merely. It's about economic justice, and about an attempt to find a third way between radical, uncaring capitalism on the one hand and radical interventionist socialism on the other. But Leo knows that in order to make his point, he's got to re-explain what civil society is about, and that includes talking about the family as its natural and fundamental unit. Well, same-sex marriage, I'm arguing, transforms the family from a natural into a merely legal construct, subjecting it to political whim. That is, it brings the family under state control and makes it subject to whatever definition the state wishes to impose. The union of two persons, the union of two or more persons, whatever. The state has the power to define the family, and if it has the power to define the family, it has the power of disposal over the family. Take the Canadian law, Bill C-38. In its consequential amendments, any of you people here in law, studying law, okay, you know that bills, they may state their point very briefly, as C-38 does, just a couple of sentences, but then there's always going to be a section appended to the law of consequential amendments, at least in the Canadian system, explaining what the knock-on effects of this law are on other existing laws. Well, when you read that section of the Canadian same-sex marriage bill, what you find is this and not much else. The consequential amendments go through the whole of Canadian law, and wherever they find the words natural parent or blood relationship or anything like that, they change it and replace it with the expressions legal parent, legal relationship, and so forth. And this it must do, for otherwise no real equality between heterosexual and same-sex couples would be achieved. Yeah. Same-sex couples may be parents, but not without moral and financial special interventions, violence, some would say, be parents of their own children. If all families are to be put on equal terms, so that there's no distinction between natural families and arbitrary, that is non-reproductive associations, then the former must become like the latter. They must be constituted not by nature, but by law. The aim of these amendments, in the words of the law professor F.C. DeCoste from the University of Alberta, and I quote, is to denaturalize the family by rendering familial relationships in their entirety expressions of law. But relationships of that sort, and I continue with DeCoste here, bled as they are of the stuff of social tradition and experience, are no longer family relationships at all. They are rather policy relationships, defined and imposed by the state. It occurs to me, writes DeCoste, that the initiatives being carried forward in this bill are an assault on the traditions of family life, and that they risk the disintegration of that way of life, at least to the extent that they lure fathers and mothers and husbands and wives into detachment from and forgetfulness of the moral point of family life. That from his article in the Alberta Law Review, 42, Part 4, called Courting Leviathan. Its methodology is what one would expect, says DeCoste. Social life will be further occupied by the state, and through the state's coercive power, social relationships will be not just redefined at law, but changed root and branch by law. End quote. Now, when the family becomes a creature of law, a creature of the state, one of the two main sources of restraint on the state is removed. The state is constrained externally by other states, internally and by international law. Internally, it is constrained primarily by two types of community, which claim a more fundamental, or at all events an independent, mode of existence. These are the family and the religious community. Precisely as communities with origins rights and responsibilities not derived from the state, but brought to the state. These are the mediating institutions that create internal boundaries for the state and to buffer the individual citizen from the state. It is therefore essential for the purposes of political liberty to see that these institutions are respected by the state. The advent of same-sex marriage has dangerously undermined the notion of a free people with free institutions. Not to put too fine a point on it, same-sex marriage has effectively made every man, woman, and child a chattel of the state by turning their most fundamental human connections into mere legal constructs at the state's disposal. It has transformed those connections from divine gifts, as Modestinus put it in the 3rd century, into gifts of the state. To that extent, it is not merely desacralized marriage by taking it out of the hands of the family and the religious communities and placing it in the hands of judges and legislators, or legislators. It has, in the process, resacralized the state. Now, some of you may perhaps already have read my book. I know Professor Webb has read a bit of it. And in any case, I think I've already said enough to stimulate questions and perhaps elicit some challenges or objections from you. I certainly hope so. But before we move from monologue to dialogue, I want to suggest to you that a state that is prepared to redefine marriage is a state that is also prepared, or soon will be, to redefine religion, so as to subject religion also to the state. Here I want you to note again Governor Bondage's statement to the press. This law does not force any religion to recognize a marriage that falls outside of its beliefs. It does not require the church to perform any ceremony with which it disagrees. In Canada, we were told similar things. The draft of C-38 and words very much like it made it into the bill itself. Says this: nothing in this act affects the freedom of officials of religious groups to refuse to perform marriages that are not in accordance with their religious beliefs. Don't you find something rather disquieting about those assurances? What's disquieting about them is not so much the ease with which the state makes assurances one day and withdraws them the next, though we can all point to good examples of that. What's disquieting about them is that they are being made. Ask yourself this question: what kind of law is a law the logic of which makes it necessary to offer such assurances? A decade ago, before same-sex marriage was conceived, had anyone conceived of requiring a church or synagogue or its ministers to perform solemn ceremonies that contradicted its doctrines and morals? Why has it been conceived of now, if only to be denied? Well, ask yourself also whether these assurances are indeed meaningful assurances. If it is, quote, as the Goodrich Court says, incompatible with the constitutional principles of respect for individual autonomy and equality under law, to exclude same-sex couples from the institution of marriage, what are we going to do with groups that insist upon such exclusion? Are we going to tolerate them? Well, perhaps. But having decided that they contradict the premises of our common polity and of our basic sense of justice, will there not be great pressure to withdraw from them many, if not all, of their current forms of public acknowledgement?